Good afternoon, everyone from Austin, Texas. Thank you all for joining us today and welcome to today's webinar, Strategies for Advancing Knowledge Through Copyright. My name is Leah DeForest and I'm the Communications Manager with Texas Digital Library. For those of you who are new to Zoom, you'll want to make sure that your microphone is muted. If you want to see who's here and in attendance, click on the participants icon in the bottom center of your screen. If you have a question or comment, please type it into chat. You can access chat by clicking on the little thought bubble that's at the bottom right of your screen, and we're going to save all of your questions for a Q&A session at the end of the webinar. Finally, as you may have heard, this webinar is being recorded, and we're going to publish the recording and slides and share them with all of you in attendance today. So a little bit about TDL. Texas Digital Library's mission, which you see on the screen, is to build capacity for preserving, managing, and providing access to unique digital collections of enduring value. We're a member-driven and service-oriented consortium, connecting our members to a statewide network of professionals working in academic libraries and archives of all sizes in Texas. And also we connect them to national and global initiatives. I want to thank our member Susan Elkins, who's here today. She's the chair of our DSpace Training and Education Group, and she's the Digital Resources Librarian at Sam Houston State University. Susan brought this idea to us and connected us with Greg and also helped us coordinate. And Susan is going to be watching chat for us today. And now on with the show. It's my privilege to introduce today's presenter, Greg Kam. He's the Director of Copyright Permissions and Information Policy at the New York Public Library. Greg, I'm going to stop sharing my screen and then you can start sharing yours.
Thanks. Let me just get my screen going. And there we go.
Looks great.
Perfect. Well, thanks to everyone for having me. And I know this is a pretty stressful time. It's frustrating and it's scary. And as someone who's in New York and has been through a surge, I feel your pain. But for the next hour, my job is to provide a bit of a diversion and share some information about strategies on copyright. So before we begin, I've got to do my standard disclaimer. Nothing you're going to hear today should be construed as legal advice. The information I'm giving is only for legal education only. I'm here in my personal capacity, and I get to now keep my law licenses at my job. Yay! So let's get into it. So why does copyright matter to cultural heritage institutions? Why do we care about copyright law? Why are we going to spend an hour of your time on a nice summer day on copyright? Well, we do that because we have to answer this question. We have to answer the question of, can I use this? It's a deceptively simple question, but it's one we've been asking ourselves, and it's a question we've been getting from our users. And that's because of the changing nature of access to our collections. A few years ago, researchers accessed 1.6 million physical objects in our collections at my library, the New York Public Library. That's an increase over years past and follows a trend of increased usage of physical materials. But for that same time period, people accessed over 127 million digital objects. That's 80 times more digital images viewed than physical objects accessed. For 100 years, we've been focusing our energy on the physical objects in our collections, but we're increasingly shifting our focus from the book stacks to the server racks. That means we're digitizing more of our collections, accessioning more digital material, all in an effort to meet the evolving needs of our users. This is an important shift for cultural heritage organizations. The shift from patrons coming to libraries meeting patrons where they are is critical to how we've been operating today and the reason why Texas Digital Library exists. But this has some implications. This change has some implications. First, libraries are digitizing their collections, whether in-house on camera stands like this, partnering with others, including vendors, all in an effort to expand access to our patrons online. The second implication of this shift to meet patrons online is that cultural heritage organizations are pushing the content beyond the four corners of their websites. They're sharing digital content with third parties to enhance access and reach users. They're partnering with entities like the Digital Public Library of America and HathiTrust. But all of this digitization and sharing brings us to the third implication, and that's copyright liability. Statutory damages are up to $150,000 per work infringed. That means if we digitize 10 items and we're held to be infringers and the maximum damages come into play, that's $1.5 million in statutory damages. We don't digitize 10 items at a time, we digitize more like 1,000 items. So if I digitize 1,000 items and I'm held to be an infringer, and in the worst case scenario, that's up to $150 million for 1,000 items. Those numbers get big and scary really quickly. And because the stakes are so high, cultural heritage institutions need to understand the risks, but also understand how they use copyright law to their advantage. Unfortunately, there have been a few copyright lawsuits against libraries in recent years, but the good news is that libraries have been mostly successful in defending their activities. The other good news is that despite the potential for scary damages, the law gives us some tools to help us reduce those damages dramatically, in some cases eliminating all monetary damages. And that's where I come in at NYPL. I'm the Director of Copyright Permissions and Information Policy. It's a long title. What does it mean? Well, there's about 100 of us who do what I do at libraries. I'm really the copyright nerd at New York Public Library. I was hired about 9.5 years ago, and I'm a licensed attorney in New York and Massachusetts. When I was hired, I was told that I have two jobs. The first job is to expand access both in our physical spaces, but also in our digital spaces. My job is to work with curators to increase access to our collections as broadly as possible so that our collections can inspire the creation of new works, new information, new aesthetics, new insights and understandings to advance the progress of knowledge and society. My second job is don't get sued. And for those of you who have headphones in, just watch the audio here. It's going to come up one more time. My second job is don't get sued and lose. There you go, cheap, cheesy graphics. Don't get sued and lose, and do those two things in that order. And because copyright is so fundamental to what we do, I'm increasingly finding myself engaged in copyright policy conversations, especially now that Congress has began a review of copyright law. A few years ago, I testified before Congress on behalf of NYPL about copyright issues. If you've got some questions around some of the recent copyright legislation, feel free to ask me during the Q&A, but I don't have any slides on it right now. Although more and more academic institutions are creating positions like mine, there are far more than 100 cultural heritage institutions digitizing material. Even on this call, we have a huge number of institutions represented that are digitizing but don't have a copyright person on staff, a full-time copyright person on staff. And that means many of you here, because you raised your hand and said you were interested in going to a copyright webinar, means that you may be asked to weigh in on copyright issues. So I'm here to provide some baseline knowledge and tell you a few stories about how we've used copyright law to expand access to our collections. So let's begin. So let's start with the basics. Think about whether you've created a work protected by copyright law today. Did you, I don't know, write a Facebook post, shoot a video, write a long email, drew a doodle, took a photograph? If you did any of those things, then congratulations, you are a copyright owner. Even if you thought you weren't, you are a copyright owner. In fact, copyright is everywhere. It has a direct impact on your work. On a daily basis, you're more likely to interact with copyright law than any other federal law. We create works protected by copyright every day, and we use works protected by copyright law every day. But despite its pervasiveness in our daily lives, it's not always well understood, and that's what I'm here for. So copyright law's foundation comes from the Constitution, which gives Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors their exclusive rights to their respective writings and discoveries. So it comes from the Constitution. And why do we have copyright? Well, there's lots of theories about it, but one of the most basic is that copyright law is a means to an end. We reward authors and creators with a limited period of exclusivity and control to incentivize the creation of new works. We use it as a means to expand access to knowledge more broadly. So the end is to expand access to knowledge and advance the progress of knowledge. And in the US, we know that this is the case because the founders were the ones who wrote the first copyright bill, and they didn't call it an act to protect my bottom line. They called it an act for the encouragement of learning. In other words, we want knowledge to be made available so that we can all learn from that knowledge. It allows societies to gain new insights, and after the period of exclusivity is over, reuse that expression to permit unlimited copying. In European countries, this purpose is often different. In European countries, the purpose of copyright law is to recognize and celebrate the authorship of works, and that the protection of those works is a moral, fundamental human right. And this difference in foundation explains why, in part, European copyright law is so different than US law. Okay, so what does copyright law protect? Well, copyright law protects a lot, and I found it easier to actually flip this question and talk about what copyright law doesn't protect. Copyright law doesn't protect ideas, procedures, processes, systems, method of operations, concepts, principles, or discoveries. Instead, copyright law protects original works of authorship fixed in a tangible medium of expression. That's original works of authorship fixed in a tangible medium of expression. So I'm going to break these concepts down a little bit. Original works of authorship fixed in a tangible medium of expression. What are original works of authorship? Well, for copyright law, originality just means they need to have a modicum of creativity, a very small amount of creativity. But creativity is still a bar. You still have to have some modicum of creativity. Things like facts, information in phone books is not original, it's factual, and therefore it's not protected by copyright law. There is, however, maybe a thin copyright in the arrangement of that data, but only if that data is arranged in a way that is creative. It might cover layout, design, color, or anything else is original, but in this case, a phone book laid out with last name and then phone number is not original and therefore wouldn't be protected by copyright. In 1999, we also learned a bit about the copying that happens on photography stands. A court told us that elements of originality may include posing the subjects, lighting, angle, selection of film and camera, but that evokes the desired expression and almost any other variant involved. But slavish copying, although doubtless requiring technical skill and effort, does not qualify for copyright protection. In other words, although the photography staff and then the library's digital imaging unit bring years of experience, care, and professionalism to their work, the photographs they take of two-dimensional objects don't create new rights for NYPL. We don't get to claim a new right in the digital photography that happens on our camera stands. So original works of authorship fixed in a tangible medium expression. We've covered originality. Let's now talk about fixation. So fixation or fixed is the second element of what copyright law protects. And fixation for the law means sufficiently permanent or stable. So the first example that always jumps in my mind, things that are chiseled into stone, those are fixed. Those are sufficiently permanent or stable. But even things like writing on a whiteboard, that's going to be protected because it's sufficiently permanent or stable. You can read it and then it can be erased. Courts have even told us that works created on computers are sufficiently fixed for copyright purposes, even if they only last in RAM for a quick amount of time. Copyright law protects books, fine art, music, and film, but ultimately the format doesn't matter. All that matters in terms of format is that it's a fixed format. So original works of authorship fixed in a tangible medium of expression. Although many of the works we've been digitizing have one layer of rights, copyrights can actually be layered in works. There can be multiple copyrights embedded in a single item. For example, in music, there are usually at least two copyright laws or copyrights involved in music. The notes on the page, the composition is one copyright, and the performance of it, the musicians playing that music is a second copyright. So when you listen to an audio recording, what you're often hearing are at least two copyrights, two separate copyrights in that work, embedded in that item. Films are even more complex and can have lots of layers of rights. It can have third-party items included in it, and it can just be really complex to deal with films. So as a copyright owner, you are a copyright owner, so what do you get? You get a set of exclusive monopoly rights. These are rights that the rights holder gets when they own a copyright, and sometimes we call these a bundle of rights. That's the right to do something and the right to prevent others from doing something. So what are those rights? The first right that you get is the right to create copies. You, as the rights holder, have the exclusive right to make copies of your work. You also have the exclusive right to create derivatives. So Hunger Games, the film, is a derivative of Hunger Games, the book. And therefore, Susan Collins had the exclusive right to turn her work, to adapt her work to create a derivative into a film. And then some of these slides make me laugh today, so I will just note that they make me laugh and we'll move on. But the third right you get as a rights holder is the right to distribute copies in a very less than 6 feet kind of way. The other right that you get is the right to publicly perform or display these works. Out in the back of the New York Public Library in the summer, or most normal summers in the before times, there would be a play, or there would be a video, there would be a movie out on Bryant Park, and people would swarm in to watch those films. Unfortunately, these all have been canceled this year. But what do you get as a rights holder? You get the right to make copies, to make derivative works, to distribute copies, to publicly perform and publicly display your works. So who can own a copyright? Well, this is a Vincent van Gogh painting that's hanging at the Museum of Modern Art in New York City. And although MoMA owns the physical object, they don't actually own the copyright to the work. Physical copyright ownership doesn't mean that you own the copyright to that work. Indeed, instead, copyright vests initially in the author or authors of a work. So when someone is writing a letter, that author is the person who wrote the letter, and they are, at least at the beginning, the initial copyright owner. The author could be multiple authors in the case of joint works, where two people work together to create a single work product or create a single work, and those thoughts have been intermingled so that you can't separate them. Even employers can own a copyright, and if the work is made for hire, then the employer is both the author and the copyright owner. So I write lots of memos on behalf of the New York Public Library, and although technically I'm the one who wrote the memo, I'm writing it as a work for hire, and New York Public Library owns the copyright in that memo and is actually technically the author of that memo. So who else can own copyright? If the author gets the copyright at the beginning, then who else can own it? Well, heirs can own copyright. Copyright can be transferred by means of conveyance, by will, or by operation of law. If there is no will and there's a way to divvy up an estate at the end, copyright can be transferred in all of these ways. Copyright can also be owned or transferred to institutions and companies. Anyone can be assigned the copyright in a work, and in our deeds of gift, my library often asks for an assignment of copyright so that we can make as many uses of works as we can. We use these deeds when the donor is the rights holder. If they're not the rights holder, they have no rights to assign to us, and therefore an assignment of copyright doesn't work. But when they do own the copyright, we often ask for that assignment to come to us. All right, so how long does copyright last? Well, today, copyright lasts life of the author plus 70 years. So life of the author plus 70, but it hasn't always been this way. In fact, it's changed over time. Once the duration of copyright law or copyright has expired, once that period of exclusivity has expired, then anyone is free to make any of the uses that are in the bundle of rights. And works whose copyrights have expired are called public domain works. When we started copyright, it was in 1790. The first copyright law the duration was 14 years from the date of publication, plus another 14 years if the rights holder asked for an extension. Over time, that has expanded, including 1976, where we changed from a date of publication to a life of the author calculus, and we've since expanded that in 1998. But there are a few quirks that you should know about here. First, this letter written by Samuel Clemens was written in 1877. And if this letter had never been published, it'd be in the public domain today because Clemens died in 1910, which was more than 70 years ago. Remember, life of the author plus 70. But there's a quirk in US law for unpublished works created before 1978 that gave rights holders in those works an opportunity to extend copyright protection until at least 2047. Luckily, most estates didn't take advantage of this quirk, but a few did, including the Clemens estate. And this letter will be in copyright through the end of 2047, and will have enjoyed copyright protection for 170 years. Limited times indeed. The copyright problem with items like this is that it's not always easy to tell whether they were ever published. And we're going to come back to unpublished works in a few minutes and talk about some of the risk issues that we encounter with these items. So what happens when someone infringes your exclusive copyright, if you're the rights holder? Well, in most situations that we encounter, the works are archival in nature and are never registered with the Copyright Office. And in those cases, the damages are the profits made by the infringement. So for cultural heritage institutions, this is the amount, the amount that you would be liable for is all of that sweet, sweet money that you are making off of your collections. Oh wait, we're not, right? Therefore, the damages are pretty minimal. There are no damages in many cases when we're talking about copyright infringement of archival works. If the work is registered, however, if the work is registered with the Copyright Office, then there are statutory damages that the rights holder can take advantage of. And these statutory damages are up to $30,000 per work infringed. And in the worst case scenario, where the defendant is held to be a willful infringer, we go up to $150,000 per work infringed. But I should note that if a library, archives, or educational institution infringes, but had a reasonable belief that their use was a fair use, then the judge has to waive statutory damages. And we'll talk more about fair use in a second, but I just want to note that if that library, archives, or educational institution has a reasonable belief that their use was a fair use, then the judge has to eliminate these statutory damages, and all we're left with is the actual damages caused by that institution. All that sweet, sweet permissions revenue that we enjoy. There's been some recent scholarship on the number of copyright lawsuits that have been brought against libraries and archives. In the last 5 years or so, the number there's been about 1,100 lawsuits involving a defendant with a variation of library or archives in their name, which happens to include things like non-cultural heritage institutions. And only 13 of those 1,100 lawsuits, or about 1% of those lawsuits, were designated as copyright infringement lawsuits. In other words, the likelihood of a copyright lawsuit is historically low, despite some of the headline-grabbing lawsuits that were filed, for example, in the last month or so. So that's what you get as a rights holder, but what about users? Although the rights holder has a set of exclusive rights, there are exceptions and limitations to these exclusive rights. And these exceptions and limitations permit users to lawfully use works without the permission of rights holders. These exceptions and limitations come in handy, especially now that the duration of copyright law is so long. We don't have a lot of time, so I'm only going to talk about 2 exceptions for now. The first one is a doctrine called fair use. And the doctrine of fair use can play an important role in achieving the goals of scholarship and education. It allows us to make uses that are socially beneficial and have little to no market impact for the original. Fair use is also critical to content creators. They use it all the time to make their art. So there are 4 factors when it comes to fair use, and these are a set of questions that we ask to help get at whether each factor will weigh in favor of or against a finding of fair use. The first factor is the purpose and character of the use. Are you using the work for commercial purposes? If you are, this factor is going to tend to find away from a finding of fair use. Are you using this work for a transformative purpose? Are you making something, are you transforming the purpose or character of the work? If you are, then this will be likely determined to be a fair use, at least on this factor. The second factor is the nature of the copyrighted work. Is it highly creative? If it's highly creative, then there may not be as much room in fair use as there would be for something that is very close to a factual work but has some minimal level of creativity. Is the work unpublished? If it is, then this factor is going to tend away from a finding of fair use. The third factor is how much of the work did you use? And was that amount appropriate for the purpose you were trying to make? Did you take the most important bits, or did you take the whole work? If you did, and it wasn't appropriate for the purpose you were trying to make, then this factor is going to find away from a finding of fair use. The fourth factor is the market impact, or the impact of the use on the market for the original. How much are your use and uses that would be similar to yours impacting the market for that original? So that's a lot of theory. Let me give you a real example. So this is Roy Orbison. In 1964, he recorded a song called "Oh Pretty Woman." And when it was released, it was a hit. It was #1 on the US Billboard Hot 100. The album sold over 7 million copies and was certified gold within months of its release. It tells the story of a lonely man yearning for a woman he sees walking by. It was a very sweet song for its time and sounds a little bit like this. And just as a reminder, if you've got headphones in, you might take them out for a second and let the audio stabilize.
Pretty woman walking down the street, pretty woman, the kind I like to meet, pretty woman. I don't believe you, you're not the truth. No one could look as good as you. Mercy.
Okay, in 1989, at a very different time, 2 Live Crew released a song called Pretty Woman. It was described as a song of degrading taunts, a body demand for sex, and a sigh of relief from parental responsibility. And I will note that there's some vulgarity here. 2 Live Crew admits that they copied elements from Roy Orbison's song. I'm going to play it for you now. Again, watch your headphones. So as you might guess, Roy's publisher didn't like the use of Roy's song by 2 Live Crew and sued for copyright infringement. 2 Live Crew argued that this was in fact a parody, that their copying of protected elements from the original song was a parody. It was commenting on the naivete of Roy Orbison's original work, and they argued that it was therefore a fair use. The court agreed and found that 2 Live Crew's song quickly denigrates into a play on words, substituting predictable lyrics with shocking ones to show how bland and banal Roy's song was. They found this to be a transformative use and therefore protected fair use. Let me give you another example. In the cultural heritage sector, we've had a few important fair use cases in the last couple of years. Google Books is a project that was spurred by the Google Books project has spurred 2 important copyright fair use decisions recently. The first has to do with Google's use of books that they've digitized. So libraries have books that they want digitized. They sent those books to Google. Google digitized those books and sent the books back to the libraries and the digital copies to the libraries, but they also kept a copy of that digital file for themselves. They used that digital file for a couple of different purposes. They used it first to extract text and use it as the basis for full text searching of books. The second was to make small snippets available to users in a form that looks like this on your screen. So Google was sued in 2005 by rights holders, and Google claimed that its uses were protected by fair use. They argued that their uses were transformative and therefore fair use. After nearly a decade of litigation, an appeals court reviewed this case, reviewed Google's uses, and determined that both uses were fair uses. Specifically for the snippet view, the search for Einstein, searching for the word Einstein, might reveal that that word was used many times in a book, but only after you look at the snippets do you realize that it's because the book is written about a dog named Einstein, not Einstein the scientist. The other lawsuit spurred by Google's digitization is the HathiTrust lawsuit. This lawsuit was filed in 2011 and was decided relatively recently. Hathi is a partnership of academic and research libraries. The partnership began in 2008 with the goal of preserving the digital assets created by the Google Books project. The primary digital asset came from the partnerships with Google. So Google, when they sent their digitized copies back to libraries, libraries couldn't, at that time at least, really handle and preserve all of these large files that were coming off of the Google Books project. They wanted to make the books more accessible to a broader audience, and they found efficiencies in aggregation, so they contributed them to the Hathi Trust. Hathi takes these digital files and uses them in a couple of different ways. First, they use them to drive a search engine. That search engine allows users to see how many times a word or particular phrase appears in a book if that book is still protected by copyright. Note that Hathi doesn't show snippets. The second use that Hathi is making is they use the copies to support users with print disabilities. The digitized text is converted to a format that's accessible for print disabled users so that they can access the books. Ultimately, the courts found that Hathi's uses were in fact fair uses. First, the court held that the full text search was a fair use. The original purpose of the text was to be read, and Hathi uses the text in a transformative way by not allowing humans to read the text, but to permit searching across millions of volumes very quickly. The court also found that Hathi's use of digital copies for blind and print disabled access was a fair use. It held that although it wasn't a transformative use, remember the original purpose was to have the books be read, and Hathi's purpose was allowing the books to be read, this format shifting for patrons with print disabilities was consistent with what Congress had intended for fair use, and therefore this was a fair use. So here's my little warning. As important of an exception as fair use is, each situation is going to be unique. This is a case-by-case analysis, and many times we're talking about new and novel issues that haven't come before a court. These are more like factors and less like rules or guidelines. We're talking about more likely or less likely to be a fair use, not a simple yes or no. And ultimately, fair use is going to be part of a larger risk determination. We'll talk more about risk in a second. The only opinion that matters, while I think something may be a fair use or you think something may be a fair use, ultimately it's only the judge's opinion that will decide whether that use was a fair use or not. And when thinking about larger risk determinations, there are non-copyright issues that may be relevant to your analysis. There are things like privacy and publicity, donor relations, indigenous cultural issues. There are lots of other issues that may come in and get involved in your risk analysis. So copyright should be part of that risk analysis. There are lots of other exceptions, but one more that you should be aware of is the Libraries and Archives exception found in Section 108. In recognition of the important and special role the libraries play in society, Congress gave libraries and archives a special set of exceptions. These exceptions are key to library services, doing things like copying for preservation, copying in response to patron requests, making copiers, scanners, and printers available to patrons, even permitting some very broad uses of older orphaned works. I'd be happy to talk more about these exceptions in the break or during Q&A when we get there. But we've now spent 30 minutes talking about theory. I'm now going to give you some practical examples. So we have used the limitations and exceptions at New York Public Library and the term of copyright to our advantage over the last few years. I'm going to give you a look over our shoulder and tell you 3 stories to help illustrate how you can use all of these things to your advantage. The first story is about the public domain or the public domain release. Unfortunately, when you're determining whether something is still protected by copyright, there isn't some magical registry or database of public domain items. Instead, we've got to make that determination ourselves. But as we were making these determinations at my library, we realized that the rights fields in most DAMs looked like this, right? A blank text, free text field. We knew we needed some way to keep track of the rights information we were developing about our collections, and we began looking for a pre-built rights database. What we found, however, surprised us. In an industry that cares a lot about standardized data and schemas, we found a significant lack of consistency in rights metadata. So we ended up building our own. This is a peek at our system that we use to record rights metadata. I help manage the institution's risk by gathering rights data about our items, analyzing it, and recording how we can use each asset. We also include lots of information about how the assets, about our assets and our rights metadata, but we rarely fill out all of these fields. These are a lot of fields for rights. But this blue box at the bottom is where we really tell the systems how we can use these works. By standardizing how we enter data and using controlled vocabularies, we've been able to make our data actionable. We've been using this data to make some interesting uses of our digitized collections. In January of 2016, we released 180,000 high-resolution images that were free to use without restriction. None, no restriction placed by us. This wasn't the first big release of a high-resolution public domain drop by us or by another cultural institution, but it was certainly one of the biggest in recent memory. And the release included things like photos by Bernice Abbott. It included early photographs of algae taken by Anna Atkins, considered to be one of the first women to publish a book with photographs that she herself took. There are also photos from the Farm Security Administration, some of which were used to create a mashup of Beyonce's Formation lyrics with images from the FSA, which we thought was hilarious. There are also prints from the Works Progress Administration, and there's another item in the release that was the Green Book. You might have seen a movie about that, but the Green Book was a travel guide published between 1936 and 1966 that listed hotels, restaurants, and bars, gas stations, and other establishments that were welcoming to Black travelers. We found that all but one of these items in our collections was in the public domain, and so we put them all online except for that one, at least in high-res. Another newspaper compared photos taken at Ellis Island that were in our collections to contemporary photographs of Syrian refugees. This juxtaposition was striking at the time and remains relevant to today's public discourse. So it sounds daunting to review the copyright status of items in your collection. When I started, I had a decade worth of digitization to review. Plus my team needed to keep up with all of the new digitization happening at the library. And today our repository contains some 2.75 million assets, give or take, about 2.75 million assets at this point. And this is our burn down chart. This shows you the percentage of items in our repository that we haven't added copyright information to. Since May of 2014, we've added copyright status determinations to over 2 million captures or over 540,000 items. We've got about 3.3% left to review. That's the very bottom right number, 3.3%. And sometimes it feels like all we do is this. My team continues to review new digitization and chip away at our backlog. And because they do such great work, I want to highlight them here. They research, analyze, and enter rights data. The team is me. There's a person named Kiowa Hammonds who actually you all, Texas Digital Library knows. He gave a talk a couple of years ago. And well, that's it. It's just Kiowa and I. Although we're a small team, we've been averaging about 100 captures per day. I wanted to show you this because I know many of your institutions are not as large or as well resourced as NYPL. Determining the copyright status of your items isn't impossible and has some significant benefits to your institution and your patrons. One way to communicate your rights status determinations to your users is to use a standardized way to express these determinations. And for TDL, folks, rightstatements.org is the standard that we've been using to describe the copyright status and reuse status of works in our collections. And we do that because Right Statements is one way to help answer this question for our users. Can I use this? When we tell our users that something is in the public domain, we've seen an increase in usage of those items. So when we tell our users what we know about the copyright status of a work, they run with it, they use it, and they use our works. Exactly what we want. The next story is about the World's Fair. This is Bill Stangone. He was the curator of manuscripts and archives at the time. He has a collection from 1939 to 1940 about the World's Fair. This collection is heavily used by researchers. There's over 1,200 feet of records here. And Bill came to me and said, can I use this? What can we do with these records? Can we digitize them? Can we put these records online? Can we make educational uses of these records? So my first step is to gather information about the items. There are, in the project that Bill was proposing, 12,000 photographs. These were promotional photographs taken on behalf of the fair. So they're all work for hires on behalf of the fair. These 12,000 photographs are spread out over 2,500 records, and there are no donor restrictions on file and also no licenses on file from the rights holder. So my second step then is to determine the copyright status of the work. And in this case, what we're trying to figure out is the work published? A key question determining copyright status for material of this age is publication status. We'll talk more about publication status in a second, but for this purpose, it's not clear whether these photos were ever published. So the third step for us is determine risk. In the worst case scenario, we'd be on the hook for over 1.8 billion with a B dollars in potential liability for digitizing and using this collection. That's about 4 or 5 times NYPL's annual budget. So not so great if we're found to be willful infringers. But the copyright status here is unclear, and we wanted to look at the argument we would make if we ever did get sued. That means we look to the exceptions and limitations in the law, and the one that we jumped on was fair use. We believe that the uses we wanted to make were likely fair uses. Another risk consideration was the fact that we believe these to be orphan works. We'll talk more about orphans in a minute. So the risk here is that even if they were in copyright, are there any rights holders out there to sue us? Well, the Fair Corporation owned the copyright to these photographs, but after searching all of the corporate records, there was no clear indication about how the rights were distributed when the corporation shut down. The corporation wasn't succeeded by another company, and so it's really unclear who owns what anymore. That means these are likely orphan works, or works for which the rights holder can't be located, usually after some reasonably diligent search. This is a problem exacerbated by the length of copyright duration. The results from one study suggest that 55% of the books in academic libraries are likely orphaned, and in special collections, this number is surely greater. So there's no clear rights holder to pursue a license with, so we can do nothing or we can take some calculated risks. One way that we help address risk is that we have a takedown policy and we have a takedown email address. That email and address goes directly to me and my team. So what's the risk here? Well, there's no evidence to suggest that these were ever registered, so the potential for monetary damages here is pretty low. That, combined with our strong fair use arguments, means our overall risk is pretty low. So the next step for us is to make a decision. So we went to senior leadership and said, these are the facts, these are the risk issues, can we do this? We think we should. And senior management said, great, yes, go do it. And so we did it. We ended up building a few interesting and productive uses of these images. We digitized them and put them on digital gallery, digital collections. We created a website that features content from the fair. And we even created an iPad application that was named one of the top educational apps of the year that it was released. So the last step for us is to record, to document our rationale. So we wrote a summary of what we think we can do with these items, why we think we can do it, and we put it into a memo that is stuck in the file and included in the rights metadata. We make this record to document our diligence, but also to help future successors understand why we made the decisions that we made. One last story, because I know we're running short on time. This is a story about menus. So the Rare Books and former Digital Experimentation Lab, Rebecca Fetterman, Ben Vershbow, and Michael Inman came to me about our projects around menus. They asked me the same questions. Can we use these menus? Can we digitize these menus? Can we put them online? We want to transcribe these menus because we really want to get the data out of it. But the OCR here is really tough to work with. We can't really run optical character recognition on it. We have lots of weird font. So instead, what we'd like to do is leverage the power of the crowd. We want the crowd to help us transcribe these things. So my first step is always to gather information. There are 45,000 menus in the collection, and they range in date from 1843 to today. This is a breakfast menu from 1843 from the Astor House. This is a menu from a staff association of the public libraries of the city of New York. And there are gems like this, which is a menu from a luncheon held by President Teddy Roosevelt. So the second step is then to determine the copyright status of the works. Are these things protectable? Is there a modicum of creativity? Well, in this case, there's not much protectable content here. These items, this menu in particular, just doesn't have much creativity. This menu, however, has much more. So some menus are going to be determined to be not protectable, but some are going to be. So we had to break these into categories. And we started with duration of copyright. So life of the author plus 70 years is the duration today. But as I said, there were different rules for different dates. These rules are complicated, but we've got lots of good tools that we can use to determine the status. But the tools require you to know whether a work was actually published. In this case, if these menus weren't published, then they would likely be in copyright law or copyright protection today. But if they were published, then there's a chance they might not be in the public domain. So when we looked at the menus, one of the factors is to determine whether something was published was whether it was freely distributed. If it was freely distributed, then it's likely to be determined to be published. And in this case, we believe that they were, and therefore they are published. It means that we need to look at whether the rules were complied with when we talk about duration. And I'm not going to get a chance to talk about too much of this, but there are some formalities that had to be complied with during certain parts of our copyright law. I'm going to skip through some of these because some of them are a little bit more specific than we have time to get into. But I should say, here, we'll do this. There are 45,000 menus in this collection. That's a lot of menus. There are, again, 45,000 menus, and there's a team of us. Although we're fast, we wanted to look at the risk of these things. So our third step is to look at risk. So even if these menus were protected by copyright, are there any rights holders out there who would sue us? Well, here's a little interesting info about restaurants. 1 in 4 restaurants close within the first year. 3 in 5 close within the first 3 years. And in New York City, the fail rate is closer to 4 in 5 close in the first 3 years. So when restaurants close, what happens to its intellectual property? It's usually not accounted for and it becomes unclear. Rights holders may not even know they own rights. So there are probably not many rights holders that we can identify, and those that we can, are they going to care? Well, for menus, for restaurants, there is no money in the menus, right? They make their money off of the food that they sell, not off of the menus. So are they going to care about these orphan works? Probably not. And again, we have a takedown policy. They send an email to take down at NYPL. We can have a conversation. So we have that policy in place. So what's the risk here ultimately? We thought the risk was pretty low. And therefore, we then went and tried to we recommended a decision to senior leadership. We asked senior leadership, can we do this? And they said, sure, go do it. And so we did it. We built a project called menus.nypl.org, or what's on the menu, where we asked the public to help us transcribe these menus. They would go on and enter the dish name and the price. And this data ended up becoming really useful. Some researchers have used this data as historical indicators of fish population health. And that's fantastic. We never expected anyone to use menus data to be able to look at the historical fish population health. But this is exactly what we're looking for, new insights and understandings in using our collection materials. And a big shout out to IMLS and NEH for funding that project. But that doesn't stop, that's not the last step for us. The last step is to record. So we wrote some memos, we stuck those memos in with the rights metadata, and ultimately documented our fair use rationale. So I'm gonna stop there. Those are 3 examples of how we use copyright law to our advantage. We haven't so far heard any complaints about any of our uses. And the message here is don't let copyright be scary. So we've got questions now. I'm gonna save a couple of minutes at the end for some parting thoughts. So Leah, I'll turn it back over to you for some questions.
That's awesome. Thank you so much, Greg. Mind blown from tip to toe. So let's launch right into our first question. And this is a great segue, that last image of the Seinfeld restaurant. I was hoping to hear a little clip from the theme song, but that's okay. We had a question from Mirko, who asks, could you say something about architecture copyright, and how should that be approached when publishing photos of architecture?
Sure. So there are always lots of questions around the buildings. Can I take photos of buildings? Can I publish photos of the buildings? And is there copyright in those buildings? So for the most part, the answer is no. No, that there is no copyright in many of those architectural drawings. In fact, it's pretty rare to have any kind of architectural drawing be considered, or any building be considered a work protected by copyright. Instead, what we're worried about are the designs, the drawings. Those might be protected by copyright because the actual architecture laid out on the page might have some protectability. But the building itself generally doesn't have copyright protection. And so we've been pretty comfortable putting images of buildings throughout New York City on our website without worry, and have never heard a complaint.
Okay, that was great. I'll see if Mirko has a follow-up question there. Oh, looks like a thank you. Thanks, Mirko. And then we have a question. Okay, we do have a follow-up question. So, and then I'll get to Shelley Barba's question. Esteban asks, so what about a drawing of a building?
Yeah, so the drawing you'll see at the very beginning of my slide deck, and you'll see again in a second, that drawing would be protected by copyright. There is some creativity in that drawing, especially artistic renderings of buildings. Those are going to be protected by copyright. But the actual building itself, like the physical building itself, probably not protected by copyright.
Okay. Okay, thanks. We're going to move on to another question. So this is from Shelley. Where does New York Public Library publish your takedown email or your takedown policies? Is it with each item, each collection? Shelley would like to do something similar at her institution, but they don't want to hide it on a deep dive webpage.
Yeah.
Go ahead.
So we ended up not publishing it right next to every image. In fact, the takedown at NYPL email address is a little bit tough to find. Instead, what we did was we created an about page of digital collections for the digital collections platform. And on that page, instead of using the words takedown, we actually have an email address that's digitalcollections@nypl.org. And what we say is that we want to learn more about our objects. We want to learn more about the items that we've digitized. And we ask people to reach out to us and let us know more information if they know more. That's generally how rights holders reach out to us. And in the past, when they've reached out to us, what they often do, they'll send us an email and say, hey, that photograph, I'm pretty sure my grandfather took that photograph. And I don't think we gave you a license to put that online. And what we usually say back is, that's great. Thank you so much for helping us identify this work and getting more metadata for this work. And well, let's talk about it. And what they often will say back to us is, well, I'm fine with you keeping on the website. Really, what I really want is a copy of that photograph. And so what we do is we send them a copy of the photograph along with the license that would permit us to keep it online forever. And we talk about the value of keeping it online and in the collection and accessible to the world. And so far, that's mostly been successful in keeping items up online where we've taken some risk.
I love that answer. It turns copyright into an opportunity rather than a gatekeeping tool.
Yeah.
I have a question that I thought of. Thanks, Shelley. I'm glad that answered your question. And I thought of a question, if somebody else has a question and wants to type it into chat. So thinking about how these items come to you and many of them being donated, how do you bake your permissions into the process before items are even accepted? Are you involved in that? Like, how, and if you are, how do you balance the donor intentions with the mission to offer items as openly as possible?
Yeah, so this is where we try to get ourselves involved at the very, very beginning. So if the donor is the rights holder in the object, we want to be right there in the beginning before we start talking about a contract. We want to be in the initial conversations between our curatorial staff and the donors. We want to talk about how those works should be used by the library, how the library wants to use those items, and what benefit it would provide to making them available online. And in some cases, the donor will get some feedback from the donor, and the donor will be willing to assign their rights to us. In fact, there are a number of collections that we have where the donor was so dedicated to the mission of the library that they assigned their rights to us and said, we want you to license these works to generate a little bit of revenue for the library to support the continued digitization of more works. So we're assigning rights to you to allow you to license works on our behalf so that you can generate revenue for the library. Now, it's not a ton of revenue, but it's helpful when we talk about digitization. So we try to stay involved as early as we can in the process. We try to keep ourselves kind of connected to donors. Now, the trick is that I've only been here for 9.5 years, and so we've been collecting for another 100+ years before I started. So in those cases, what we're often doing is reaching back out to rights holders. Or we've got collections where the items were donated and the rights holder wasn't the donor. In those cases, we do reach out to rights holders when we want to make uses of works. We talk about the mission of the library. We talk about the value of having the items online, and we often will get licenses for our uses. Yeah, we often will get licenses, and we try to do it equitably. We try not to, bully people into those licenses, but we do try to advocate on behalf of our users.
Awesome. Thank you. So bake it in, don't bolt it on at the end.
Yep.
Do you have time for another question?
Yeah,
we have one more.
We can go. Sure.
Okay, great. This is a question from Victoria. Could you talk more about fair use? If we are a museum wanting to create an exhibit to show at multiple locations and online outside of our physical building, what is our responsibility to get written permissions to use images in particular?
Yeah, so I'm going to talk about this from the context of the library. We do the same. We have physical exhibitions, although I guess we used to in the before times, and we will at some point again in the future. I'm really not too concerned about what happens within the exhibition space. I think that there's a lot of good, transformative fair use arguments about how those items were selected and curated and brought together in a way that enhances, informs, transforms those works. And so I'm pretty excited to be able to do that connection and that collaboration. When we go online, there can be more risks on the fourth factor, because now we're talking about putting images online that may in some way impact the rights holders market for those works. And so what we try to do when we put images online, we try to include as much of that text around the items online as possible. So when we talk about description of the items or the juxtaposition of items or kind of the impact of those items, we want to do all of those things around those items to really tell the story about the item. Now, in some cases, that's going to be enough for fair use. In other cases, rights holders are going to disagree. There are a few rights holders who pay very close attention to museum websites and will want to have a conversation if you post an image of theirs online, even if you have a really good argument around fair use. And in those cases, we might seek licenses. We might get to know our rights holders a little bit more and be able to reach out to them in advance and get permissions. But I think the more context that you can build around the items, the more of a story you can tell by combining multiple items into an exhibition, into a show, and you talk about those items, the stronger the fair use argument is. But ultimately, as I've said, it's going to be a fair use call, a risk call that you're going to have to make, looking at your institution's risk profile overall.
Greg, I've got 2 more minutes on this whole webinar on my watch, and we have 2 really great questions in the Q&A that I understand if we can't get to it today, they would almost be webinars in and of themselves. Can I get your thoughts on that? On if you have a few extra minutes?
If we're all willing to run a couple minutes, I'm happy to run a couple minutes over. I know that we only have, technically only have a couple minutes left, so happy to run over if you need to.
I'd love to, and if our question, the folks who had the questions could stick around. Also, for anyone who needs to go, just really quickly, we have been recording this. We're going to publish this on TDL's YouTube page and on our website, and we'll make sure to share it back out with you. If you need to step away, we got you covered. So let's start with Carolyn. At our archive, we try to research the copyright on all photo requests, but we ultimately tell our patrons it's their responsibility to determine copyright. Is there another way we should approach this issue?
So I think that's probably a good way to do it. That's one option. Lots of institutions do it that way. My library, we end up, because we have some more resources, we ended up investigating the copyright status on our own. So we will dig into trying to determine whether the item is in copyright or not, because we have to do that work anyway. We need to, once the item is digitized, we're going to have to make a call about whether it's in copyright or not and what the uses we can make. So we dig into those issues, but we also, just like you, when we are unsure about who the rights holder is or what the status is, we do ask we ask the patrons who are coming to us to take on some of that responsibility and take on all the responsibility for rights clearance and rights permissions. And we do that through an indemnification where if the use that the person makes actually triggers a copyright lawsuit and we're dragged into that lawsuit, we expect that the client would indemnify us and defend us in that lawsuit. So it's a balancing. We look at each of those as a risk, and we think about, who are the potential rights holders here? Do we need clearances in place before we make this available? Or are we so unsure of the status that there's a good argument maybe in the public domain and we're not going to require any clearances?
Okay. One more question, and this is from Teresa, and I think we're going to cap the questions here so we can We don't want to let you go, Greg. You're just going to have to stay with TDL forever. Sorry. We have a question from Teresa. Do you have advice that you can share about working with copyright in an international context, specifically in relation to materials published and or held outside of the US?
So there's a couple of versions of this answer. The easiest version is that as an US institution, we follow US law. So if a work is published outside the US law helps us determine the copyright status of that work in the US. So for example, if I've got a book that was published in London, that book was published in 1924, even though that work may still be protected by copyright in the UK, in the US, that work is in the public domain, and therefore we treat it as a public domain work within under US law. There are some institutions on this call and outside of this call who are working internationally, who have campuses outside of the US, and they may need to dig into the laws of the jurisdiction in which they're operating. But we tend to focus on the jurisdiction that we are operating within and that we're targeting. When we start talking about trying to look at the copyright status of a work in every other country, there's 198 countries or whatever it is, that's basically impossible for us. There are some tools out there that are trying to get at that, but you have to have really good factual information to be able to feed the algorithm that then tells you the copyright status across the world. So the best advice that I have for you, it's a rabbit hole that you can go down, but we tend to stay in the realm of we are a US institution and we comply with US law. Regardless of where the item was published, there is US law that helps us determine the status in the US. And that's the easier version of that. The harder version is trying to figure out what the local laws are in every country. And that is time that will just kill all of the time that you have on a project. So follow US law, worry about US law, and worry about other law later.
That's all we have for questions, Greg. Did you have a few more things to go
over? I do.
Over?
I just have a couple of parting thoughts for us. So here are my parting thoughts as we think about this. So this question, I'm gonna go back to this question about can I use this? Although there are fair use determinations that we can make on a case-by-case analysis or case-by-case basis, there are some general principles that tend to favor fair use. With the growing desire and capacity to digitize collections and make them broadly available, fair use is the most critical copyright issue for research libraries today. That's why most of the questions we just dealt with were fair use questions. And we are changing from being risk averse as a cultural heritage sector to understanding that risk is necessary to achieve our mission. Codes of best practices in fair use are being developed by organizations struggling with fair use. We spoke a bit about these best practices earlier. And I'm not saying that libraries should digitize all the things and put everything that we have online. Libraries aren't pirates, but it's not civil disobedience to assert the exceptions and limitations granted to libraries by Congress. We shouldn't be constantly afraid of being sued. Instead, we should be constantly afraid that by not asserting the limitations and exceptions that Congress has given to us, we're actually hurting our mission. Just as we keep our doors open despite the risk that we'll get sued for a slip and fall that takes place in our buildings, we should similarly be willing to take reasonable and informed risks when we believe that our uses are likely to be fair uses. We can do it, we can take smart risks to meet the needs of and match the evolving demands of our users to inspire the creation of new works, advance knowledge, and fulfill our purpose as a cultural heritage institution. Those are my parting thoughts. Let me turn this back over to you, Leah, and stop sharing my screen.
Sorry, I was muted. I was so wrapped in what you're saying. Greg, thank you so much. I can say personally that I've learned so much from you, and not just what you had to say, but how you said it. And you made copyright seem far less terrifying to me personally, so thank you for that. As for those of you who are still on the call, again, we are going to record this. Greg has very graciously offered to let us host this content on our YouTube and in our DSpace channel. We'll send out an email when that's ready to go. And then just finally, we appreciate all you do, Greg. You and Kiowa are certainly doing some great work there. And also we appreciate all the work that our friends, colleagues, and member librarians do every day. And I want to thank everyone for participating in today's call. And just hope everyone stays healthy and as sane as you possibly can. And take care. We'll see you all soon.
Thank you.
Thank you, Greg. Have a great afternoon, everyone.